Judge, welcome this afternoon.
Thank you.
I see you brought some guests, I bet, because we haven't had anybody here all day, so they must be with you. You want to introduce them to us here?
I would be happy to. So I have my husband Ken, my youngest daughter, well, my only daughter, Anna, my son Aaron, my son Joseph, and my son Isaiah.
Okay, well, welcome.
I made my mom stay home.
Whenever you feel comfortable, why don't you start your opening remarks?
All right. Justice Wiggins, Commissioners, thank you for your time this morning, or this afternoon. I guess you guys are long into the day by now. F. Scott Fitzgerald once said, "Don't forget who you are and where you come from." In the last couple of weeks, I've had the opportunity to travel the state and meet many of you, speak to the rest of you almost, and I am glad to have had that opportunity. This process has made me reflect on a question I was frequently asked, which is, where are you from? I think it's interesting that no matter where we go and people we meet, we always want to know where someone's from. I think that's because we're interested in where someone's from because it gives us an idea of who they are. I do not believe that where you're from has to define who you are, but it certainly shapes who you are. The process of being a candidate for the Court of Appeals has given me the opportunity to really consider who I am and what I would offer the Court of Appeals that is different from the other candidates. What I have come to decide after a lot of thought is simply that I have myself to offer. Each of us is the sum of our own unique experiences, and what I would bring to the Court of Appeals is those experiences. My strong work ethic, my service to others, and the expertise in the areas of law I have practiced over the last 20 years. So where am I from? Madrid, Iowa. It is a tiny town with a single stoplight and, of course, a Casey's. I was raised there by my parents with my 4 brothers and sisters. My parents instilled in us the value of faith and family, a strong work ethic, and a commitment of service to others. We watched my parents live that every day of their lives. They spent countless hours volunteering for our church and our community, and frequently us kids were there beside them as they volunteered. My parents taught us to work hard. It was a frequent lesson or a statement in our house that anything worth doing was worth doing well. That was not a lesson that was lost on any of us. We were all expected to attend college, and because we were also expected to pay for it ourselves, I went to a junior college and then transferred to a state university. I managed to, between scholarships and numerous part-time jobs, pay for my education without any debt. I also, during those years, volunteered for many different activities. In fact, it is where I met my husband of 25 years, when we were both participating as youth camp counselors at a local youth camp. It was my husband who encouraged me to pursue my dream of law school, and he has been a tireless supporter of me and my career ever since. I attended Drake Law School, and I focused primarily on juvenile law. I also obtained my master's degree at the same time because I believed it would complement my desire to work in the public sector. One of the commissioners in our comments or conversations asked me which was harder, law school or maintaining a 4.0 in my master's program. My response was simply having my first baby in between my second and third year. After law school, I only applied to agencies where I could do juvenile court work. I was hired at the Juvenile Public Defender's Office here in Des Moines, and I routinely carried a caseload of well over 200 clients. I was responsible to meet with each of them, visit the places that they called home, attend staffings, review reports, and of course, be their advocate in court. I quickly became very knowledgeable of substance abuse issues, mental health issues, domestic violence, the landmark study called Adverse Childhood Experiences, or shortened ACEs, the impact of trauma on children, what the meaning of permanency was, and why it is so important that children achieve it early. I loved that area of law, and except for life intervening and kind of messing up your best laid plans, probably would have stayed doing that role for a little longer. However, in 2002, my third son, Nathaniel, died of sudden infant death syndrome. And while dealing with the grief of his death, I decided it was time to switch careers or change direction in my career. And I moved from child advocacy work to representing adults in criminal defense cases. In my years as a public defender's office, that transition was fairly easy because I was already representing juveniles in delinquency cases. Many of the clients I represented had very unique stories. In fact, the stories that they have are ones for the legend book. The clients I represented, however, I always felt like I could have a positive impact on them. Sometimes all it took was simply listening to that story. I handled hundreds of cases in the public defender's office, from simple misdemeanors to Class A felonies. My first jury trial was actually a murder trial, where my client was standing trial for the same murder a third time. During my years in the public defender's office, I also volunteered to do extra work. I volunteered to try civil commitment cases, represent defendants in civil commitment cases. I was a staff attorney who trained new attorneys hired by the public defender's office in their training program. And I put my master's degree to use by working on a committee that created the electronic database for all of the public defender system. In 2010, I was then appointed as a district associate judge, primarily assigned to the juvenile bench. At the time of my application, I had 457 pending cases. Juvenile court has tight time constraints, and as a result, I spend the vast majority of my time on the bench listening to hearings, and rulings have to be written outside of court hours. I routinely try 3 to 5 termination cases a month, each of them requiring lengthy rulings to be written. I am the trier of fact in delinquency cases, which means I have to be knowledgeable of criminal law as well as criminal statutes. I also am responsible for reading hundreds of reports each month so that I know the needs of every single child that appears in front of me and the progress of their parents. During my years on the bench, I have seen neglect, I have seen abuse, and I have even seen death. But I continue to work in this field because I've also seen the resiliency of the human spirit. I have presided over an adoption of a 17-year-old girl who, after years, was finally convinced that she deserved a forever family. I have watched parents who have overcome and triumphed over their addiction and then turned full circle and thanked this judge for putting them in jail, because it was that act that interrupted their drug use long enough for them to get into residential treatment and start that long road to recovery. So, who am I? I am the daughter of a family from small town Iowa whose parents convinced her that if I just put my mind to something and was willing to work hard enough, I can achieve anything I desired. I am the student who put myself through undergrad as well as law school, all while working, being married and raising a family, and volunteering on a regular basis in my community. I am the wife of a devoted husband and 6 amazing children. I have tried during my years as a parent to instill in them the same things that our parents instilled in me: sense of faith, sense of family, sense of service, and of course that hard work ethic. I am the attorney that has spent the last 20 years devoted their career to juvenile and criminal work. 70% of all of the cases heard by the Court of Appeal are in those 2 areas. And I am the judge who, despite a caseload of 450 cases, frequent hearings, endless reports, and time constraints, simply refuses to write a subpar ruling because I believe litigants deserve to understand the reasoning of a court's decision, even if they don't agree with it. Who am I? I'm a sum of all of those things. And it is those experiences that would make me an outstanding judge on the Court of Appeals. I thank each of you for your time and effort in this process and your service on this commission. Thank you.
Thank you, Judge. We'll start with questionings from Mr. Gray.
Judge, can you tell me, what is your biggest frustration as a district associate judge today?
Today in particular, or just in general?
In general.
In general.
Yeah.
I think that the district associate court caseload is very difficult. It's just a volume of cases that we do. As I mentioned in my remarks, I have 450 cases pending. It's difficult for someone, especially with my personality, who wants to do things really well all the time, to sometimes kind of let that go and just continue with the process. So I think part of the issue, or probably the biggest frustration, would be that. The other frustration that I sometimes see, particularly in my area of law, is that juvenile court is often the training ground for new attorneys. So people get out of law school, they need to get in a reputation and get some experience, and they can go on the court-appointed list. We frequently get court-appointed attorneys. I was a court-appointed attorney, so I'm okay with that. But I think sometimes you see inexperienced attorneys appearing, and the rights that are at stake in juvenile court are just so important that I think that sometimes is frustrating to me to see.
Thank you.
Mr. Harbach?
Thank you, Justice Wiggins. Welcome.
Thank you.
In our discussion that we had privately or in our interview, I expressed my concern for caseload and turnaround of opinion. And your appropriate answer was 450 cases, which you illustrated today. But one thing that I did not really, which really sunk in our other interview, and I didn't hear you expound on it too much here, but most of your opinions have timelines associated with them as a requirement, which can be different than other levels of the judicial system. Could you just remind me of that very quickly?
Sure. In juvenile court cases, delinquency cases are expedited. In adult criminal cases, you have a right to a speedy trial within 90 days. In juvenile court, that's within 60 days. In child in need of assistance cases is where you hit the real crunch. If a child is removed from their parents' custody, they are required, or parents are entitled to a hearing within 10 days. The adjudication hearing, which is deciding whether or not the child is in fact in need of the court's assistance, has to be held within 30 days. Dispositional hearings, which is kind of what you could compare to maybe a sentencing, what the parents are required to do in order to have the children returned or the case successfully closed, is done within 60 days. Then all permanency hearings for children have to be within 1 year. If you file a termination petition, there are timelines regarding the termination petition has to be filed within 30 days, and the court has to hear it within 60.
Yep.
So
That answer, I was really just getting to your experience as far as related and being able to kick out opinions in a timely manner.
Yes.
So thank you for your answer.
all right.
Ms. O'Brien?
No questions, thank you.
Ms. Roberts?
No questions, thank you.
Ms. Conover?
We keep hearing the numbers in terms of the Court of Appeals caseload, and obviously your experience encompasses the big percentage of work that the Court of Appeals does. But help me understand, what is it about appellate review of these juvenile court cases, either the standard or the amount of information the court is looking at? What is it about that that would make it imperative, as you're telling us, to have somebody with juvenile court experience on this Court of Appeals?
So I just want to make sure I understand the question. Are you asking why my background would assist in that? Is that what you're trying to ask?
Yes, and it's intuitive that it would, because the Court of Appeals is handling that volume. But as I understand it, it's a de novo review.
It is.
You have a lot of heavy fact-finding, this being reviewed. And the legal standards are not, maybe intuitive to those of us who don't practice in that area. And so is there, if you could just help us understand why bringing that experience to the Court of Appeals would make for good Court of Appeals rulings.
Okay, so what I would say is there is so much information that I have been trained in as an attorney, first as an attorney, but then as a judge, that I think Court of Appeals judges just don't have because it wasn't their area of expertise. Things like understanding substance abuse issues. The average person who is addicted to methamphetamine, the relapse rate is over 80%. I think that kind of just innate knowledge, understanding the services that were provided, reviewing those records and the decisions that the court made, the underlying court made, who's more familiar with those families and the services that are available in that area, would improve or help outcomes in the Court of Appeals. I think that a lot of that information, anyone who's read a cold transcript of their own work knows that there's so much loss in between what is in that cold transcript and what happened in that courtroom. And I think it's really important to bring a perspective of what happened in that courtroom for those years leading up to that. And I think that would benefit the Court of Appeals.
Mr. Bloom?
Well, I was sure impressed with your dedication to the law and to the community, and I shared that with you, I think. One of the highest evaluations I think I've given anyone. And, you know, I'm one of, like, we're all struggling a little bit with this issue as a district court judge assignment, a prerequisite to be on the Court of Appeals. We've been talking about this literally all day with almost every applicant. I don't want to ask your question for you, Jeff. But you sort of represent an interesting argument against that. I tried to talk about it earlier, and is the 5C unique in that the district court judges don't really have to participate with juvenile court?
So I'm not going to presume to know what every district does. But what I will tell you is the Supreme Court several years ago kind of issued a mandate that we have one judge, one family kind of belief that a judge should see a case from the beginning until the end. And that's in Polk County when district judges stopped reviewing those cases, and then it went to judges who are dedicated to juvenile work. So in Polk County, that's 6 juvenile judges that all day long, that's all we do. In more rural areas, in my experience with talking to the other judges that attend our training, is it's usually district associate judges who usually have split duties. But as far as I know, that's generally not the practice anymore, to have district judges participate in the juvenile cases.
Okay, well, thanks for explaining that. I thought that was helpful.
Thank you.
Mr. Goodman?
Yes, thank you, Your Honor. Judge Seymour, thank you for your application. We had a nice talk on the phone, and you've been out of law school about
20 years.
20 years, and 9 of those years as a judge. The question that asks about your trials before juries indicated 1, and I'm wondering, because I sort of remember you having quite a few trials in your first 10 or 11 years of practice, many of them Class A felonies and otherwise. Can you talk to that issue a little bit, just so I can get a better idea of what your trial experience is in adult court?
Certainly. The question is the last 10 years, and so I limited it to that. Most of my cases that I tried actually were Class A's. I tended to work well with the county attorney's office, and usually I could work out a fair resolution to cases. So probably the majority of the cases I tried were more serious offenses. I don't have an exact number anymore, but I know that I tried at least 5 Class A murder cases. In juvenile court before that, I couldn't even guess how many cases I tried. We have lots of termination trials. That's a trial. It's just a trial to the bench. And I'm sure I participated in hundreds of those.
Okay, and the Class A would be a life imprisonment
Yes.
without
Murder in the
possibility of
first
parole.
degree.
Okay, thank you.
Ms. Diekma?
No questions.
Ms. Sinclair?
No questions.
Mr. Bevel?
No questions.
Ms. Law?
No questions.
Mr. Diaz?
No questions.
Mr. Becker? Berger. God, I'm getting worse.
questions, Your Honor.
Everybody's gonna have a different name before I'm done today. Ms. Bowden?
Yes, thank you. You have considerable time management experience. If you were to be elected or appointed to this position as a Court of Appeals, what do you think would be the most challenging for you
Well, time management-wise or just in general?
in general?
So I am a person who loves the people. It's one of the reasons I've chose the work that I have done over the years, but I've also spent 20 years doing that. So I think sometimes being in an office sounds lovely, but I think I would probably miss the direct contact with litigants.
Thank you.
Thank you. We're out of time. I'm sorry, Ms. Pearson.
That's okay.
So we will thank you for coming here today, and we wish you the best of luck.
All right, thank you very much.
Thank you, Your Honor.